Hello, we're going to be talking today about the idea-expression dichotomy in copyright law. The question we'll be addressing is, are there problems with the idea-expression dichotomy in copyright law? We will start our presentation by giving a brief explanation of the idea-expression dichotomy. Then we will move on to discuss the limitations of the idea-expression dichotomy using relevant cases to give a better understanding of these limitations. Then we will conclude our presentation.
So, speaking about what the idea and expression dichotomy exactly is, we need to look into the Copyright Designs and Patents Act of 1988, in short, the CDPA. In the CDPA, it's written that copyright, in essence, is the right to prevent others from copying or reproducing your work. The idea and expression dichotomy is very often discussed within copyright law, as copyright protects the idea, the expression of an idea, but not the idea itself. So, for example, if I have an idea for a book or a painting or a game, and I discuss it with my friends in speech, it's not that is not going to be copyrighted. But if I write down the book, or if I actually make the game, that will be the expression of my idea, and that is going to be copyrighted then. So during recent years, the courts have acknowledged that it's difficult to draw the line between protecting ideas and expression. This is, in short, the idea and expression dichotomy, which we're going to discuss today.
The first limitation is that judges may be subjective in some cases when it comes to personal opinion because reasonable minds vary. This problem is often faced in some cases where the judge's personal view comes into question in deciding whether there is copyright infringement or not. This can be explained through the case of Designers Guild versus Russell Williams, which took place in the year 2001. It is a very famous case because it raised controversy in the decision of artistic copyright infringement. Here, the dispute was about a fabric design, Ixia, which was produced by Designers Guild Limited. As copyright law suggests, that any original work produced will be protected and will acquire an exclusive right for copying. This makes the Ixia design exclusively owned by Designers Guild Limited. Another design company, which is Russell Williams, came up with the Margaret design, which was very similar to the Ixia design. As a result, Designers Guild Limited alleged that Russell Williams infringed the Ixia design when they produced the Margaret design. At first, the House of Lords ruled that Russell Williams had infringed the copyright of the Ixia design, but after appealing, the House of Lords reverted its decision. The House of Lords stated that breach of copyright is dependent on whether the copying is for the whole work or a substantial part of the work. The decision is made by doing a visual comparison, which includes determining the similarities and the differences of the two works. If any copying is found, then the court has to determine whether these similarities constitute the whole work or a significant part of the design, meaning that the copying has to be for the whole work or for a part that is substantial to this particular design for infringement to be considered. This whole process is a question of substantiality and degree and not law. Visual comparison makes it harder for the judges because, as I mentioned earlier, in such cases the decisions are often subjective.
So, another limitation of the idea and expression dichotomy is the fact that the idea and expression could merge. So, if an idea is expressed in detail in the work, then copying the idea may also involve copying the expression. And in such cases, copyright will protect the copying of the idea as well as the expression, which is kind of controversial, if you can say, within copyright law, because if you look at the broad definition of idea and expression, it's mentioned that the expression is copyrighted and not the idea. But in the case of a merger doctrine, both of them will be copyrighted. So, this usually happens in cases when there is a limited number of ways that a concept or an idea can be expressed, and then there's little difference between the idea and the expression, therefore the two of them would have been merged. An important case for this limitation is the IBCOS Computers Limited versus Barclays Mercantile Highland Finance in 1994. In this case, a programmer created a computer program for his employer, but then he switched employers and he created a similar program for his new employer. So what happened then is that he used the same codes, the same structures, and the same modules within that program. The judge, who was Jacob J., found that literal copying of the source code had taken place, and he also commented on the literal copying, saying that copyright cannot prevent the copying of a mere idea, but it can protect the copying of a detailed idea. So, in short, in this case, the idea and the expression had merged, and the judge used traditional British principles to examine the scope of the copyright within computer programs, and he acknowledged the subsistence of copyrights in non-literal elements of the computer program, and then expanded the extent of copyright protection of non-literal elements to cover program structure and design features. So, just to summarize this limitation, the expression and the idea could be merging if there's limited ways to express an idea.
Another limitation that we came up with was that in the absence of any current definition and scope of idea or expression, it would remain up to the court's own value judgments on how to incline the outcome of a case concerning copyright infringement. Following this, by virtue of distinction, courts have created two categories under ideas, such as ideas that are not protected for being mere abstractions, and those that are protected by having a direct connection with the expressions of idea. The confusion between the idea and expression of idea is very visible as to the different case outcomes results that were presented on this matter. So I will be taking the case in Nova Productions Ltd versus Mazuma Games and others from 2007. In the case of Nova Production versus Mazuma Games and others, the claimant alleged copyright infringements in the computer game named Pocket Money, from where the defendants, being Mazuma and Belfort, have allegedly copied into their own games the trick shot and jackball, similar features. The claimant confided on the following kinds of copyright work. 1. Artistic work, being the sitemap graphics and the frames generated and displayed on the user. 2. Literacy work, being the claimant's design notes on the program which he wrote to implement the game. 3. Dramatic work embodied in the game itself. And 4. Film copyright. Later on, the defendant abandoned some of the copyright works on the basis on which he claimed as originally deriving and wanted an advanced consideration for artistic and literary work. After that, the judge examined three games to which he reached to a conclusion that there are certain similarities between them. Nevertheless, I quote, "In my mind, each game plays in a very different way. Although it is not important the way the games were played, however, the features that are alleged to be copied. When examining the features of the game, the judge derived at the fact that some features were a general idea implied by Pocket Money, but implemented differently. Now, one may argue that the features of the defendant's game were not an idea but an expression of idea, since there are details that play within the whole segment of the game. And even if it were to be a feature of a general idea, by taking an example of Ian Fleming's copyright of James Bond character, it derives to the point that features that have a general idea can be protected. However, it solely depends on the angle on which courts look at. So in the James example, if I were to take the James Bond character and the script that I really liked, however, not using any type of similar images that were used in the James Bond movie, or any specific dialogue that James Bond was using, such as I am Bond, James Bond, I would still not be able to recreate that script due to Ian's flaming estate having a monopoly over the idea of James Bond. Concluding to this limitation, it can be clearly noticed following the progress of this case that the court is open to different interpretations of the copyright of idea and expression of ideas. Conclusion? In the history of copyright, has viewed ideas and expressions as two different categories between which a blurred line was drawn. However, it is arguable that there are no unexpressionless ideas. The variety of words used to attempt describing the idea, expression of idea, have only led to producing a lack of clarity in this field, hence why the different case results given by judges who are confused themselves. Courts thereby produce an ambiguity when they use the term expressions or relate ideas to expressions without making clear that not all expressions are protected. Due to courts' lack of clarity, yes, we agree that there are many issues arising from applying the supposed dichotomy. Thank you very much for watching.